Thank you all very much for coming to the first in a series on wealth and succession planning. My name's Scherzade. I've met many of you already, and this is my colleague, Alfred here.
Good afternoon, everyone.
Sadly, I have to introduce us because our chairperson, Clara Ingenhouse, who's the chair of the AmCham Legal Committee, couldn't be with us today. So I have to do it for ourselves, which is a little embarrassing. So about me first, since I'll be speaking first. I'm a registered foreign lawyer at Alden Lee and Me. We're a local mid-sized law firm. I'm not going to tell you a huge amount about our firm because it's in our notes that we've given you. But my practice focuses on the needs of the individual and families. Often they are high net worths, and I regularly advise on complex cross-border wealth planning and general commercial matters. I have only been in Hong Kong 3 years, and I trained predominantly in London in family law. So I use the experience that I have in family law to when I'm handling wealth planning matters. And in particular, I'm very passionate about advising whole families on how to protect themselves, their wealth, and their children. I myself am a member of the legal committee, and I wanted to thank Clara in absentia for helping me organise this opportunity to speak to you today. And now I'm going to introduce Alfred, who I work very closely with. Alfred's a partner in the dispute resolution group at Alden Lee and Me. He's been a partner since 2007, having qualified in 2000. He has carved out a niche for himself in that he's one of the most highly respected contentious probate lawyers in Hong Kong and was recommended as such in this year's Chambers and Partners. He is therefore best placed to talk about the pitfalls that he has come across as a result of bad drafting in testamentary documents. And I say testamentary documents because it's not just wills, and in his vast experience as a practitioner in family disputes. We have been working closely together since I joined the firm, and we have been building up our private client practice group together. We've also collaborated on various legal publications, such as LexisNexis Hong Kong Encyclopedia of Wills and Precedents, the LexisNexis Practical Guidance for Wills and Probate, and Hong Kong Lawyer magazine. And with the embarrassing bit over, is there anything I missed out?
No, you have done a very good self-introduction. I'm sure that you will be very successful at the next interview. Don't leave us yet.
Okay, so let's find the first slide. I'd just like to say, before we really get cracking, that we would like it to be as interactive a session as possible. So you'll find that the handouts that you've got, they don't actually give you any answers. It asks all the questions, and most of the questions are based on the experience that we have. Obviously, the questions we frequently get asked. So it's a bit like an FAQ, what we're going to do with you. If you don't have time to write down all of the answers, don't worry. Please do contact us, and we will let you know anything that you've missed out. So by way of introduction, we've got 10 bullet points, but I actually believe that this is far more than 10 things that you're going to learn about making a will. Firstly, we'll just briefly give you an overview of the probate process, when you have a will, when you don't have a will. How would the law act if you don't have a will with regards to distributing your estate? How does the law deal with guardianship of minors if you don't appoint guardians? Who is an appropriate person to appoint as an executor or trustee and/or a guardian? How to make sure that the people that need to know about your assets know about them, that is your executors. The potential pitfalls of appointing as trustees members of your family. Common reasons for family disputes. That's where Alfred will take over from me to talk about contentious issues and what is likely to happen if there are family disputes over your estate. What happens if you disinherit a relative? What happens if you make a will and you lose it? And finally, is it acceptable to make a handmade will? Now, I did prepare a handout for you that is a glossary. am quite aware of who's in the room and that most of you know these terms, so I don't propose to go over them, but it's there for you so that you can, if we do say, if we do have any legal language that you're not sure about, hopefully glossary answers your questions. And if not, please stop me and ask, or stop us and ask. So, we've basically split up this diagram into two halves. So the during lifetime part, where the kinds of things that individuals should be thinking about is all around planning: estate, wealth, succession, tax planning. And some people may wish to set up a trust during their lifetime. And then the things that we talk about post-death are the registering or proving of a will at the probate registry, applying for the grant of probate or the grant of letters of administration, and then actually administering the assets. And then the third point is the trust setup question mark. Why question mark? Some people don't set up a trust during their lifetime. It may become effective only upon death. And so that's another one of the things that can happen after a person passes away. So with reference to case studies, we're going to go through what we think are the most commonly asked questions. So starting off with a great example of someone who's done it exactly right. Alan is married to Belinda, and they have 2 children together. One is 8, one is 5. So very clearly they are minors. Alan made a will 2 years before he passed away, leaving everything to Belinda. He and Belinda have also appointed guardians in a deed of appointment of guardian. What happens now that Alan has passed away? Well, like I said, Alan has done everything right. The deed of appointment of guardian comment is actually a bit of a red herring. I put that in there so that it would make you think that there was something to say about it. There's actually not. Because in this situation, Belinda, the wife, and the surviving parent of the children, is going to automatically have parental responsibility for those children. And so the deed in this scenario isn't ever going to come into effect, actually. What does come into effect is the will. And by making a will, Alan's making everything as straightforward as possible for his loved ones. He's making the probate process more straightforward, which essentially means that it's quicker to get your hands on the assets in this situation. There's less paperwork to complete, and much less likely to need a lawyer in this scenario, because the probate process is that much more simple when you have a will than when you don't. So you can actually save lots of legal fees by simply making a will up front. With case study 1 continuing on the same facts, what if Alan never made a will before he passed away and there's no deed of appointment? Well, the deed of appointment, again, is the red herring. That actually doesn't matter too much. But if you don't make a will, and this is all assuming that Alan is a Hong Kong domiciled person, what is going to happen is the rules of intestacy of Hong Kong will apply to Alan. That means, in this situation, the law basically dictates what happens to Alan's assets and not Alan himself. His wife will get all of his personal chattels. That's one of those archaic words. Basically, all his personal belongings are going to go to his wife. His wife is going to get 500,000 Hong Kong dollars from the estate. And then everything that's left over, the residuary estate, is going to be shared 50% to the surviving spouse and 50% to the children in equal shares. And what's probably, for most married couples with children, what the law's doing is actually probably what they would want. They would want to for everything to go to their wife and children. But it doesn't take into account, for example, dependent parents or a dependent sibling. That's slightly more unusual, but if you did have a dependent that you're giving maintenance payments to, the law doesn't incorporate them at all in this situation. As well, if you actually make a will, when you have children, you don't need to appoint more than one person as the trustee. There are pros and cons about that. We could go into that, but the point is that the law says that 2 trustees would have to be appointed in this situation. And it gets really interesting, not to mention complicated, if you then bring into the facts. What if, in a situation, Alan and Belinda are married, but they're separated? So if you have an estranged spouse, what then happens if you don't have a will? In that situation, you probably don't want your estranged spouse to be able to get half of your estate, the 500,000 lump sum, all of your personal belongings. So if you don't make a will, you can see that there are many pitfalls that you can actually experience. Moving on to case study 2 then. Different people this time. Charles is married to Diana. They don't have any children. Both Charles's parents are still alive, and Charles passes away. Just as a reminder, Charles is a Hong Kong domiciled person as well. So what happens now that Charles has died? Again, we look to the rules of intestacy and we see what they say. So many married couples are amazed to find out that in this situation, the surviving spouse doesn't take everything. It gets split in the following way. So the wife, in this case Diana, is going to get all of the personal belongings. She gets a net sum of 1 million Hong Kong dollars, and the residue is split 50% to her and 50% to the surviving parents in equal shares. So that astounds most people, because they think when they get married that they're going to share everything with their spouse. And if you don't make a will, then the law actually doesn't reflect what most people think would happen. Another commonly asked question then is, who can be appointed as an executor and as a guardian? So before I read out the case study, most people automatically think of family. But what we're going to demonstrate through this case study is that family isn't always the best solution. So Francesca is married to Eduardo. They have 4 children together. Both Francesca and Eduardo have made wills, and they were a mirror of each other. They both died tragically in an accident. Francesca and Eduardo had also appointed guardians for their children in a deed of appointment of guardian. They both appointed Francesca's sister as the guardian and the executrix, and therefore the trustee of their wills. The sister, that is the guardian and the executrix in this situation, she dies 2 years later, whilst the children are all under 18. So there are two main issues here. First of all, it's great that they've actually taken steps to do some estate planning. So they've got a guardian and they've got someone acting as the trustee. I think the main problem isn't actually the guardian, because when we talk to people, we do recommend that they always have a contingency plan. So let's assume that the guardianship is not the problem here. We've got 4 children that need a guardian. You can actually appoint a substitute for that permanent guardian if you make a deed of appointment. So assuming that's happened, the biggest problem here is actually who is going to be managing the trust fund that's been set up in the wills. So the surprising thing here is that the sister that's passed away, if she has made a will, the person that's the executor and trustee of that will actually become the 4 children in the situation's trustee, which means that the parents who took steps to do their estate planning and make sure that there was someone to look after them both financially and in terms of their emotional care as well, they have no say over who's going to take over as a trustee. And if you imagine that when you pass away, all of your assets actually get transferred to the executor or the trustee, and they become the legal owner of those assets. That is a very high degree of trust you've got to have in that person. And in this situation, they have no idea who would be taking over that role. So you can see that it's really important to think very carefully about who should be in these roles when you're appointing these people. So, what usually follows on from that question is, well, if I appoint a family member or a professional to be my trustee, how are they actually going to know what I have, and how will they know what to do with my assets? So, case study 4 is Jed, who has passed away, and before he dies, he makes a will and a letter of wishes, to which a schedule of assets is attached. So what is this, and why does he do this? It is possible, it's perfectly possible to put a schedule of assets in your will. So that would be essentially just a list of everything that you have. You can say what you want to happen to it individually or not. But the benefit of making a letter of wishes and attaching a schedule of assets the way that Jed has done here is that that remains completely private and confidential to Jed and his estate. When a person passes away, their will that they've made, if they've made one, it has to be registered at the probate registry. That then becomes a public document. So if you go ahead and make a whole assets list within your will, you should be mindful of the fact that that's actually going to become public information. And then, at least with the letter of wishes, you can keep it private and still say how you want things to be done. And as far as possible, your trustee is under a duty to follow your wishes as nearly as closely as possible. The only reason that they wouldn't do that is when it's not in the beneficiary's best interests. So we always recommend a letter of wishes which is a non-legally binding part, which simply complements the will, which is the legally binding part. I should also mention, actually, another very good reason to make a letter of wishes is if you are appointing a professional, you can save a lot of fees because a professional obviously charges for their services. And if you've got a letter of wishes which states how you want things to be done and also includes your assets, it just means that there's a lot less due diligence for that professional person to do, which will save in terms of fees. So lots of good reasons to make a letter of wishes as well. Now, the juicy stuff, I think, it's safe to say, is all about disputes and what happens when things actually go wrong. So Alfred will take over from you.
Thank you for leaving the best part to me. I hope you don't mind that I stand up because I want to see all of you. When I'm stuck at the corner, I cannot really see you guys. Can I ask one question? Sorry. Can I ask one question? The most common reasons for family disputes. Have a guess. What do you think is the most common reasons for family disputes?
For money.
Money. Anywhere? Any other reason? Okay, I would say 2 reasons. 1, money. Bingo. Money is a very good incentive for family disputes. And I'm saying that with the view that a lot of assets are actually appreciating in an astronomical rate in Hong Kong. Think about a family house, let's say it's a small apartment somewhere in AmChamHK. The family might have got it at what, 10,000, 20,000 Hong Kong dollars, like 30, 40 years ago, and now it becomes a charming walk-up that can be sold at like 3 million Hong Kong dollars, or generating a yield of like 20,000 Hong Kong dollars per month if it's nicely decorated, with a yield of like 10%, 12% per year. Wow, that's a lot of money. Think about it. If you're inheriting $100,000 from your parent, it's very different from inheriting 1 million from your parent. And it's very different from inheriting 10 million from your parent. So when money is involved, the bigger it is, the bigger the incentive for the family to go into dispute, especially when they all have their differences beforehand. Remember, at 3 years old, your sister grabbed your toy car and say, "That's mine, it's not yours. I'm not gonna give it to you." It's something that you will hear from your children these days. But then, you know what? Some people do remember that when they are 40 years old, when their parent passed away. And they will always remember that my sister is always the preferred child. I'm always the one who's left behind. So I want to get even. Why am I not entitled to inherit the same thing that my sister is entitled to? Why is she always better than me? So these are all differences that can generate a lot of family disputes. And of course, if you're talking about siblings, these are already very good reasons. Think about when marriages becoming more and more complicated. A lot of people actually have more than one marriage. The first wife and the second wife usually don't really get along. If they get along, it's very uncommon, I would say. Not many people are like Dr. Ho. Even Dr. Ho has 4 wives, and some of them don't talk to each other. So when probate involves, the first wife and the second wife can get into a fight. We'll see later. How about this dispute? How are they gonna deal with in Hong Kong? That's my specialty. Litigation in Hong Kong. Can I ask how many people have first-hand experience about litigation in Hong Kong? All right. May I ask, is it a pleasant experience or is it a very nasty experience?
It's a huge waste of time.
It's a huge waste of time. I don't know if I should agree with you. I don't know if it's politically correct for me to agree with you. But I can only agree with you in the sense that it's actually very time-consuming. If we're talking about proceedings, of course, there are different stages. Pleadings will be exchanged, documents will be disclosed, witness statement will be prepared, trial will be conducted. From the beginning to the end, a probate case probably 3 to 4 years, usually, especially if one party is determined to delay the whole process. That 3 to 4 years is usually right. I remember one case that we started in 2010. We went to trial last year. So 4 years, very common, and we are not talking about a long trial. So family disputes can be very, very long and convoluted, and I'm sure that the lady at the back will agree with me that lawyers do charge a very handsome fees in Hong Kong. So, again, how can the risk of family disputes be minimized? If let's say the family doesn't want to spend money on me, they don't want to they don't want me to be the ultimate beneficiary of the whole estate. What can they do? I would say is that there are many different ways to minimize the family dispute. But then, first of all, a good estate planning strategy is very important. It can be as simple as a will, but wills are always very volatile to attack. It really depends on how good the will is prepared. So there can be other ways, from setting up family trust to restructuring the family wealth to the sense that it will be carried on for generation by passing the probate process that Scherzade has just described, which is also a very convoluted process, and make sure that the family legacy can carry on and pass throughout the generation. This is something that we try to encourage our client to do, to bring especially the Chinese family on par with the Western family, like the Hilton, the Rothschild, and other famous names. Okay, can we have some case study? This inheriting a relative. So we have this high net worth individual who wants to give everything to his wife, and he doesn't want to leave anything to his adult son, who has been benefiting from him by way of $1 million per year for the past 10 years. First question, do you know if in Hong Kong there's any forced heirship rules, that is, one person must leave something to the immediate next of kin, like spouse or sons or daughter? In other words, can he disinherit his son? Yes? Please raise your hand. No? Please raise your hand. No response whatsoever? No answer? Okay, we have one answer. He cannot disinherit his son?
Well, he can write a will to disinherit him, but there's laws that if he was dependent for more than 2 years, then the son should benefit from the estate.
Yes, I would say yes, but I'm not too sure about the 2 years rules. So what I would say is that there's a claim that the son may make against the estate when he passed away, because he has been financially dependent on him. Maybe, maybe not. It's not clear on this, but he may have a claim against the estate for financial provision under the inheritance provision for family independent ordinance. So that is the potential risk and pitfalls. Of course, or a US $10 billion estate, legal fee may not be a big issue. A millionaire and billionaire Hong Kong dollars not a big issue. But then, the problem is the grievance and the stress that he brings to the immediate family member, that is his wife, in dealing with that claim. Because when we're talking about family disputes, a lot of background will be disclosed, a lot of circumstances will be disclosed, which may become public knowledge, especially if it has to go to court and go through trial, when the family members have to be cross-examined by the counsel. So, does he want his family to be subject to all these potential high-level dispute, high-profile family dispute? If no, how can we minimize that? One of the many ways that I would suggest is that perhaps he can write down written instructions explaining why he's disinheriting his son. Or perhaps he can even tell his son about that before he passed away, so that he will understand his decision, and if he has any grievance, deal with it before he passed away, so that the son would not suddenly receive this bad news from his family lawyer and say, oh, you're not entitled to anything in the estate. Think about his son. He may not be very happy if he knows that his old man has decided to leave him with nothing. Next slide, please. Okay, now we talk about if we lose your will. This case study is about Luke making a will before he dies. The executor, Michael, who is his brother, has a copy of the will by email. Luke didn't tell him where the original of his will is kept. When Luke dies, Michael goes to Luke's home to look for the original of the will. He searches high and low, but it's nowhere to be found. Michael diligently checks with all Luke's nearest and dearest, and even checks Luke's paperwork in case it's locked in the desk drawer. It cannot be found. Bam. What happened? What can he do? Can a scanned copy of the will be used to apply for grant of probate in Hong Kong? Can I have a raise of hand again? I know that you're not very responsive to my question, but yes, can I have a raise of hand? Do you think that you can probate with a scanned copy of the will? No, nobody. How many actually thinks no, he cannot probate the scanned copy of the will? 1, 2, 3, 4, 5, 6, 7. Okay, so we have like 40% of the attendees here today who thinks that the scanned copy cannot be probated. The answer is yes, it can be probated. How? This is an actually very complicated process because a scanned copy, who to say whether the deceased Luke actually signed it and actually he believes that it is his last will and he did not revoke it by making a new will. It is all up to Michael to prove that. So, if he has to probate the scanned copy will, first of all, he'd better find the 2 witnesses who would witness the will and say he did sign that will and this is the genuine original copy. If the will is prepared by a lawyer, he might as well need to ask the lawyer for a copy of that will and say that this is the will that he executed in front of those lawyers and the scanned copy represents a true and complete copy of the original will. And then he has to explain why he cannot find it. And he also has to explain to the court that there's no reason for him to believe that he has changed his will before he passed away. Otherwise, he cannot. Otherwise, there is a presumption that Luke actually destroyed his will to revoke his will. It's not an easy process, but then there are ways to deal with it. It just means that, again, it's time and money. So, the message of this case study is that it's very important to keep your will in a proper place. Where is it? Safe deposit box? Probably. If you're putting it in the bank, the safe deposit box in the bank, what the executor has to do is to make an appointment with the Home Affairs Office in order to take inventory of everything in your safe deposit box, and then put together an inventory list and apply to have the original will taken out from the safe deposit box in order to have it probated at the probate registry. Again, it is a very, very time-consuming exercise. So, and what's the alternative? In Hong Kong, there's no central will registry. So, nobody would know whether a will is actually made, by who, and when. One of the ways that you can find is to circulate a circular as the weekly circular published by the Law Society. The lawyers at the Law Society will check the list and see whether they have kept a copy or the original of the will in the deposit box. And if the original is kept in the law firm, then all you have to do is to contact the law firm, take the original and have it probated. It's easier. It's definitely better. So, keep your will properly. This is the message that I want to bring across.
As we have time, you might also mention about where we prepare a will and it isn't executed. So it hasn't yet been, so everything's been done, but hasn't actually been signed.
Okay.
That's also an interesting one.
Okay, she's actually referring to a case I'm currently doing. A will prepared by the lawyer for a patient on his deathbed. Prepare the will according to instructions, bring the draft to the patient, he has to look at it, make some comments, and say, why don't you change it and come back in 3 days so that we can have it signed? Fine. He passed away that night. So, in the will, it says that his siblings is going to inherit, let's say, half of the estate, with the remains to some of it to the secretary, a few $1,000 to the maid, and then the rest to the children. So, the siblings now has to go to court and ask to propound that draft will and say that this is actually the last will of the deceased, even though he didn't sign it. The case hasn't gone to court yet. We haven't had a trial, so we don't know the outcome. But I can see an uphill battle by the siblings who benefited from the will. He has to prove that actually, at the time of his death, that is in the middle of the night, that he hasn't had his final change of mind and decided that this is the final will. He wants his estate to be distributed as such. The first question that I would ask is that, are you sure that at the time of his death that he hasn't changed his mind? He hasn't had the final thought? Should that be the case? Why did he make all these comments before he passed away? Well, all these questions await to be answered. And of course, again, it's a very time-consuming and a very costly exercise, with an outcome that is very much unknown. So, the answer to all these questions is that if you have a will drafted, sign it as quickly as possible. Next slide. Thank you. Okay, we have now another case study. This one I want to give you 1 minute because there's a will actually at the last page of your handout. This is a homemade will. It's a very simple will, isn't it? Can I have a show of hands whether you think it's a will? So nobody thinks that it's a will. Okay, there's one. Okay, good. Is it a will? I'm not sure. What's the problem? Can anyone tell me some of the problems that you can spot from this very simple will?
There's no witnesses.
Yes. Bingo. No witnesses. How am I going to probate it if there's no witnesses? How am I going to know that this signature is the signature of Ned James Dalton? Very, very big question mark. Because if I'm the brother, I would definitely make something like that so that I can be the beneficiary, right? Yeah. That is already one question mark. And then the second question mark I would have is, who is the executor? Who is going to ask for this to be probated? No executor appointed. Another problem. The third one is my Ned James Dalton leave all my worldly assets to my brother Ted. Who is this Ned James Dalton? Is this Ned James Dalton the person who just died? How am I going to prove that it's the same person? There can be 2, maybe 3, or even more Ned James Dalton. I haven't gone to Facebook yet. I haven't seen how many of them are registered on Facebook. It can be 10, maybe 20. How am I going to prove it? And then my brother Ted. What if how can his brother prove that he is actually the brother of Ned James Dalton? How? Birth certificate, maybe? What if the birth certificate doesn't say his name on the birth certificate is not Ted? What if the parent's name on Ted's birth certificate and Ned's birth certificate are different? You may wonder, how could they be different? We have come across so many cases, especially in Hong Kong, when we're talking about 40, 50 years ago, when it's not computerized, that we have parents' name appear like that in the brother's will, in the brother's birth certificate, and then differently in the sister's birth certificate. They can even have different surname because the Chinese name can be spelled differently in the English and it all depends on the register or the officer who registered the birth at the time. So it can be very confusing, and actually for a piece of document like that, it creates more headache than convenience. And one of the many issues that we draw our attention to when we prepare the will is that it's not just about who inherits your estate, but also to minimize the troubles that you are going to bring to the family. Think about the family member losing you. It's already painful enough, especially as an untimely death. When you have to subject them to all this kind of hassle, this is kind of unfair, isn't it? We have come across homemade will that's even worse than this. And the trouble that we have to go through for the client is not a problem. Especially if we're talking about, let's say, a wife leaving everything to the husband. But at the same time, she has a family of parents and siblings who has been receiving financial maintenance from her from time to time, not regularly. And then she made a will leaving everything to the husband, who may not have a very strong relationship with the family. What would happen? Well, the family would be aggrieved by the death, but at the same time they lost the financial dependence. They suddenly have to worry about their livelihood, which is very imminent issues for them. It's not just about law. It's not about rightly entitlement. It's about their living. They need to go to the social welfare department to ask for the social security, which is also a painful process. These are all we are trying to help to our client when they have to make their estate planning. What will happen if grant of probate is applied for with the will that is so problematic? So the important message that we want to bring to our client is that making a will is not a piece of paper that you scribble on. It requires some thoughtful thinking and some professional assistance. So go to the professional and ask how they can help you with preparing a simple will. All right?
Just with this supposed will,
Yeah.
there's another, we've seen quite a few similar to this, and that's why we've done this one. But another interesting thing is where it gets even juicier, if you like, where you've got it written in the first person, and then suddenly it's as if somebody else is writing it and it's gone into the third person. So instead of saying I and my brother, we've seen something that said I blah blah blah, and I leave everything to her brother or his brother. And that's another really interesting, that brings up so many more issues, and it's very interesting but very complicated.
Yes. Again, we do not want, well, these cases can be interesting, but that's not something that we want to happen to ourselves. Leave this soap opera drama to other people. With ourselves, a properly drafted will to avoid all this trouble. So I think we have all the case study already. So I'll leave it to you to sum up what we have learned so far.
Like I said, I think there's more than 10 things there, and I'm sure that you must have a lot of questions, so I'd just like to open it up to you to ask anything that you'd like to. If there's anything that you don't wish to ask in front of people, Alfred and I are going to stick around for a bit, so please feel free to come and talk to us. But are there any questions now? Sorry, I think.
Thanks very much for a great overview. I wondered, you mentioned so husband and wife having the mirror wills. Does that mean, when you say mirror, so should everything be exactly the same, including beneficiaries, ultimate beneficiaries or remote beneficiaries? I mean, will there be any problems if, I think of the case of sort of these common disasters, which unfortunately we've seen a few in Hong Kong with families traveling, and you know how when you say mirror, is it 100% mirror? I guess that just to define that a little bit. Thank you very much. I'm a corporate lawyer, so I at Deacons. Thanks very much.
And
Robert Wall at Deacons.
You're on the legal committee.
I don't think I am now. Unless they put me back on. Thanks.
Okay, but there's a big difference between a mirror will and a mutual will.
Okay.
So I think that maybe that might be also a little bit what you're asking.
Right.
A mirror will, there is no obligation for it to be an exact mirror. So that's what you're asking. So no, you can say different things. It just so happens that vast majority of couples do make them exactly the same. They're just a mirror of each other. Mm-hmm. That isn't the same as a mutual will, where you actually are making an agreement that everything will be the same and that you won't change anything within that before you pass away. And we've actually written something about that and suggesting that it's not a good idea to do that because in life things change, because of circumstances changing, life-changing events such as separating from a spouse, divorce, and deaths. It's not something that we would recommend.
The only thing that I want to add is that even though we see a lot of couples making mirror will, and the contents are completely in mirror with each other, it's the same. What I want to emphasize to the couple is that just because your husband or your spouse is making a will, doesn't mean that you have to make it exactly the same as it is. And you do not have to make any agreement with your spouse not to change it in future. This is most important because we do not want anything to come up at the end and say, he or she did not want to make that will in that form, and she's only making it subject to the pressure or undue influence from the spouse. So this is something that we always make sure that our spouse, our couple clients will understand, and they will and also understand their right to change their will with or without the knowledge of the spouse in future.
Thank you for the presentation. It was very helpful. Now, you mentioned in the case studies the fact that the case studies assumed that the people involved were domiciled in Hong Kong. Now, many of us are foreigners and having a presence here, but a presence in our home country. And I know it's probably complicated based on the country where you're from, but can you give some general guidelines on what you suggest to people who indeed have an address in Hong Kong, but are coming from another country, have assets in the other country, and therefore the will should be probably, I assume, taking into account the different international arrangements. So are we thinking about then putting a will in place following Hong Kong standards, Hong Kong law, or do it in our home country, or do we do it both?
Okay, let me go over that.
Not a straightforward answer.
It's not a straightforward answer because everyone's situation is different. And when we are talking about legal service, we always emphasize on the cost and the benefit that we are going to bring to the client. So each family situation is different. It very much depends on the jurisdictions that they have assets in, the value of those assets, how they're going to deal with those assets, and the particular probate or succession process of that jurisdiction. I'll give you a very good example. When we're talking about a French client who moved to Hong Kong to develop their career, and they have accumulated a substantial wealth in Hong Kong, but at the same time they have assets in France. Language itself is already a big difference, let alone the jurisdiction. We are in a common law jurisdiction, and they have a civil law system. The probate process is very different. How to streamline it? The easiest way to do is to make a will in Hong Kong to govern the assets in Hong Kong, or maybe other jurisdiction in other common law jurisdiction, while you make another will in France, which they still use holographic will. That is, you write your own will and deposit it with the notary. This can easily streamline the Hong Kong probate process by only proving the Hong Kong will, which is a very straightforward process, instead of proving a French will that requires translation, foreign legal opinion, and other headache. So, for that example, 2 wills. For other example, case-by-case basis.
And so, in terms of, you were also maybe asking about how to determine domicile. The reason that we didn't really want to go into it is because it's completely factually based. So it really, it's very much dependent on the individual circumstances. So that is why, with all of the cases we talked about, we had to really say that's why I kept saying Hong Kong domiciled, because even if you've been here 7 years or 20 years, really depends on where are you maintaining assets. For someone like me from the UK, it's extremely hard to lose my UK domicile. So that's why we've made it very general. And if you have very specific questions about domicile and we can tailor it. We would have to tailor it to every individual circumstances.
Yeah, take her as an example, who has been in Hong Kong for 3 years. She has been telling everyone about that, so it's no secret. 3 years in Hong Kong with a substantial connection with the UK. She has no intention to abandon her domicile in the UK. The biggest difference will be tax. For UK domicile individual, the worldwide assets will be subject to inheritance tax, and anything above the new rate band will be subject to 40%, except certain allowances and exemption. So it is very important to have yourself properly advised as to your domicile, your potential tax liabilities that your assets may be subject to should you pass away, and to have a good estate planning strategy to minimize such tax liabilities. Yep.
I think this lady had a question, unless it's been answered.
Hi. You said something about a trustee becomes a legal owner of the assets. Is that not something that is actually quite scary?
Indeed. Actually, I must say that we have a few cases when we are advising the beneficiaries that the trustee, for example, named in the will is someone that they cannot trust. Everything will be vested into the trustee to be distributed among the beneficiaries after all the liabilities, funeral and testamentary expenses are paid. So the trustee actually has a lot of power. Think about, for example, a $1.2 billion assets vested in one particular sibling who is regarded as not very savvy in financial planning, who has been losing money in his own investment and businesses, and who is living in, let's say, Australia. I'm giving this case because this is exactly the case that we've done in the past couple of years, and we've successfully asked the court to remove that particular person as executor only because the beneficiaries cannot get along, and it is efficient and cost-effective to appoint independent executor or administrator to administer the estate instead of vesting all the estate on the executor named in the will. So the court has ultimate discretion into deciding who should administer the estate, and again, this is something that would lead to a very costly and time-consuming dispute.
But can your company be a trustee? Can your law firm be a trustee?
Yes, actually we do. A lot of clients would name our law firm as a trustee, and usually the equity partners will become the executor. They will approve the will, and they will administer the estate, and everything done by the law firm will be subject to professional scrutiny, and ultimately, with the professional insurance in place, we will make sure that everything will be done properly.
So that means you have to be, that means it's more legally binding. That means that the trustee, if it is your company, will be subject to a lot more restrictions than, for example, if I made a relative a trustee.
Correct. The most important point for us to be a trustee instead of a relative is that we have the professional knowledge and we have the professional reputation that we have to protect. So we have to make sure that everything must be done properly for the benefit of the beneficiary. So this is one of the protection that we can offer to our client to make sure that things can be done properly and the beneficiary can get their right entitlement without much of a dispute.
Thank you.
So glad that you asked the question, though, because it's a constant difficulty to explain it to everyone that we see. What the pitfalls are of appointing such a family member. Because I've had the first-hand experience of someone getting very upset with me when he thought I was suggesting that he couldn't trust his own brother. So it's very difficult for professionals like us to discuss those issues, but it's essential that we do. So we do always bring it up. And then the other side of it, because you said, is it not a scary thing? Well, apart from the risk factor, it's also so time-consuming. I had this poor guy on the phone to me yesterday just saying, I don't have time for work when I'm handling all of this stuff, and so I want someone else to deal with all of it, because it is incredibly time-consuming.
So you have to mention that an executor named in the will will not be remunerated if he's not professional.
Yeah. So when he was saying to me,
so he is doing everything for no compensation.
And actually, so sorry. And in addition to that, so sometimes an executor is also a beneficiary, but not always. So it's possible that they're really doing it for no benefit, for no personal benefit whatsoever. So it's also, if you are thinking about making a will, really do bear in mind the fact that it's a massive burden on the people who are asking to do it.
My question relates to this. I just want to find out if you guys act as trustees in the context of professional trust companies where you would actually address that issue. So in this particular context, I think the lady's question relates to where the settlor loses control slightly and you have this trustee who might lose independence. So if you form a separate company, and if you have, for instance, the settlor and a law firm like yourselves to guide the trustee to make decisions, it's also a very good alternative to setting up a will. We've seen that happen where people, that's how they manage their affairs. And I just want to find out if you guys act as these trustees in the context of professional trust companies.
So I believe that we talked about a situation when a will trust is in place, which a professional independent trustee company is named as the executor, and the trust is formed after the death of the testator. Am I right?
Well,
or interfidal trust?
It can apply to both, where the trust is formed before or after.
Okay.
But the benefit that we've seen is where the settlor remains involved.
Yes.
And that obviously provided that the settlor is still alive. But my question really is, do you guys provide those services as well? Can you be, for instance, a director along with the settlor of the private trust companies? Do you do that?
Okay, it would very much depends on our relationship with that particular client, because as a trustee, we owe duties to the beneficiaries, and especially in terms of becoming a director of the asset holding company, underlying asset holding company, we owe duties towards the company, duties towards the beneficiaries. We need to make sure that we are in the capacity to discharge these duties before we can take on the huge burden, and of course the fee arrangement as well. So there's an obvious benefit for us named as one of the director of this asset holding company. But then it really depends on our relationship with the client and see how we can add benefit to the ultimate goal of the client, that is to protect the family for the benefit of the beneficiary. So an alternative that I would like to say is that we can act as a protector of the family trust that the family check up. So the benefit of this is that we don't have the actual day-to-day involvement in the operation of the family trust or even the operating company held by the trust. At the same time, we can involve in the important decision being made during the lifetime or post-death of the client, so that we can make sure that the trust can be operating in a proper manner with the ultimate benefit of the beneficiary.
To play an overseeing role then?
Correct.
Okay, great.
Thank you. I think there's a question over the gentleman over there in the back.
Yeah, just to follow on from what the lady was asking about appointing professional executors and trustees. It is quite common these days for people to write a will and appoint 2 or 3 joint brothers or sisters to be joint executors and joint trustees. And I think my understanding is if they can't or don't want to do the work, they can at that point then engage professionals. They can shop around a little bit and negotiate fees with different law firms and executors. So I think these days it's quite common for people to actually appoint brothers, sisters, family members in the will, who then in turn have got flexibility to appoint professionals if required.
Correct.
Rather than appointing the law firm in the will who writes the will, because I think a lot of the fees that the law firm gets is then from the probate work.
Correct.
That was one point. My other question, just going back to the situation of having assets in different countries, as the gentleman mentioned, that a lot of expat clients here have got assets in 2, 3, 4 or more jurisdictions, and I think it's generally regarded that it's good to have country-specific wills for those places. As you're involved in the probate, I just wondered, in Hong Kong, if somebody has 3 separate wills, let's say, for Hong Kong, UK and Thailand, for example, to what extent does the Hong Kong probate court need to see wills for other jurisdictions?
Okay, I think I will answer the second question first because it's much easier. The probate court always asks for these will in other jurisdiction by providing a copy. This is what we expect.
A copy is sufficient.
They don't need the original. That's the first thing. The main thing is to make sure that the Hong Kong will is not revoked by these will made probably after the Hong Kong will is made. So they only need a copy. To answer your first question, yes, we can wear 2 hats. Either we can be the legal advisor of the executor named in the will, or we can be the executor ourselves. If we are the lawyer for the executor, we will act as an advisory role to provide necessary assistance, legal assistance during the probate process, and if we are instructed to do so, to assist in the administration of the estate process. This is what I want to emphasize. If we are not instructed by the executor to assist with the administration of the estate, the property property will be vested onto the executor for his disposal. So the beneficiary will also be still be subject to the question that they have. Can they trust the executor when everything is vested in their name during the probate process? And this is where the dispute comes from. If professionals are named as the executor, the whole administration process must be dealt with by the legal advisor, by the lawyer, and the beneficiary will have a peace of mind as to whether the estate will be administered properly. So, I will answer the question.
Yeah, thanks. And just one other quick one, please.
Yes.
Again, with regard to the multi-jurisdictional issues,
Yes.
to what extent are you able to advise on multi-jurisdictional wills, or particularly, US estate tax, UK inheritance tax, and estate taxes that may apply to clients who've got assets in those jurisdictions? Are you able to talk about that, or are you more restricted to doing Hong Kong wills for Hong Kong assets?
We are Hong Kong advisors, so we only advise on Hong Kong laws. What we can only assist with the client is to line them up with the other jurisdictions, with the lawyers in other jurisdictions, so that they can get independent advice as to how they can best strategize their estate planning for minimize their tax liability.
Thanks.
The UK as well, though, because I'm a registered foreign lawyer, so we do have Hong Kong and England and Wales practicing certificates being held in our firm. But as Alfred says, we're part of a network of very trusted advisors, and I mean, just to give you an example, I'm dealing with someone with assets it's quite straightforward, this one, but Hong Kong, the PRC and the UK, and we can basically handle the whole lot. And that's what makes it very interesting, actually, is being able to do the work ourselves, or if we are working with other people to be able to trust them, and we can still advise, like a one-stop shop.
Yeah. All right.
Thanks.
So anything else? And as I said, we will be sticking around. Please come and speak to us about anything you'd like to. And thank you so much. Thank you for coming today. Thank you for your attention.